Welcome to this breakout session concerning standardization and IPR. I am Bardo Schettini, Director of Legal Affairs in CEN-CENELEC, so I am a lawyer, as you can imagine. I have here three speakers, distinguished speakers that I will introduce to you in a few minutes. We are here because what we would like to see, all of us, is what is actually the relation between standards and patents. So when we have talked, we have seen this morning, we have heard this morning patents be mentioned various times. And also, I found very interesting a kind of a magic triangle that you have seen of relations between standardizations, innovations, and IPR, mainly basically patents, because IPR is more than patents, but here we're really talking about patents. So how can we really create the bridge between standardization, innovation, and patents in a way that can keep, just in a very simple word, everybody happy? So the speakers that will drive us through the discussion this afternoon are, three guests, three gentlemen. So the first one is Tim Pohlman. Tim is a researcher, a fellow researcher actually you have been making research for the European Commission, WIPO, the German government on issues related to standards and patents. You're also the founder and CEO of IPR, which is a company dealing with research, and you will give us some highlights on drivers and barriers to standards activities as well as patent activities. Then the second speakers will be Laurent Tonnelier, and you are also a CEO of Mobilid, which is a company very active in standardization and also in patenting. And you will give us some highlights on the good experience that you may have in combining patents and also standardization activities. And the third speaker will be Jed Owens. You are a very senior and experienced person working in the European Patent Office. If my notes are correct, you are the coordinator for public policy issues at the European Patent Office. So 25 years of experience in the patent world. So certainly, I think that you will give us a very good hints on what do's and don'ts. Let's put it that way. What we should do, what you should take care, and also the challenges that are linked with patents. Before going really into the core of our discussion, I would like to tell you something about this. I think you have received this nice little paper. If you have questions, suggestions that you don't want to share with the audience, but still you want to ask them, do not hesitate to write them down, and then they will be collected and put on that wall, and we will pick them up later during our discussion. Okay, so let's go on. I would like to give you to set a bit the scene on our discussion this afternoon. First of all, we talk about patent, we talk about standards. What is a patent? Many of you know it, maybe others they don't. So a patent is a set of exclusive rights granted by a public authority, or European authority, national one, to an inventor to manufacture, use, or sell an invention for a certain number of years. So basically, a patent gives to the patent owner an exclusive right. So you are, as a patent owner, you have the right to basically to stop any others to use your patent unless you want it. So exclusivity, I would say, is really the key word. Sorry. Okay, now what is a standard? This is a very formal, the definition of standards. I've noted down somewhere the definition that Scott has given, and I think maybe it should be better. But in any case, let's say that it is a document established by consensus. We have talked about consensus this morning quite a lot, and approved by recognized bodies, so it could be CEN-CENELEC or national standardization bodies, that provides for a common and repeated use technical solution taking into account the state of the art on a certain given field. So basically, the essence of standards, as we have seen this morning, is sharing knowledge and to make really knowledge widespread as much as possible. So it seems that at first sight, actually, we have two conflicting interests here. We have the patent holder, who has a right of exclusivity, and the standardization field, the standard users, that wants really, we look for, actually, universality of use through standards. So how can we combine it? And this is the reason why we're going to have the discussion this afternoon, because we would like really to see how we can bridge these somehow opposing interests from the different stakeholders. So I will not elaborate more on how to promote innovation, because we have already seen this morning that both, and I come back to the famous triangle that was showed by the CEO of AGFA this morning, both standards and patents are really related and promote innovation. This is, I think, is quite clear. So I would not really elaborate more. I would like to pass the floor to Tim for your presentation, and after oh yes. Okay. Well, Jackie.
Sorry, Bardo, just a reminder. We wanted, just like we did this morning, to get a sense in the room of what we've got. It'll take 1 minute, Tim, and then it's over to you. But just again, to get a feeling for who we've got and where you are on this issue, how many of you have either considered or have indeed filed for a patent? Show of hands, if you would. Okay. And how many of you have engaged in standardization activities in the framework of your work?
Oh.
For how many of you was that the same person putting their hand up in reply to both? Okay, so there's a number in the room who are already doing it. And for the rest of you, and I don't know whether you've got your green and red cards, we can do this by show of hands, it's probably the easiest. In your opinion, based on what you know, how do you see the interaction between the two? Do you see it as a great benefit to use them in combination, as we're just hearing, and we're going to explore how to do it? Or do you not see it as a particular advantage and you prefer to keep the two things separate? Who thinks combining is useful and can be a very effective tool? Okay. And who at the moment can't quite see how you square the universality versus the exclusivity principle? Okay, well, shows we need this panel. Back to you to try to explain it.
Some work to do. Okay, Tim, the floor is yours.
Yes, thank you very much for the kind introduction. As already said, my name is Tim Pohlman. I'm CEO of IPR, former researcher at the Technical University of Berlin. And back in our times of the research lab, we did a questionnaire, a survey in the summer, asking companies motives to patent, motives to standardize. So when we look at the slides, top 5 motives to patent is very much closely related to the definition of a patent, because why do I file a patent? I want to exclude others, I want to penetrate the market, I want to differentiate myself from others, and I want freedom to operate. So why would I want to standardize something? Also very much related to the definition, because I want a common basis of a technology, I want to communicate maybe with I want systems to communicate. In the end, I want to facilitate a technology, and I want to spread implementation and adoption. So in the end, again, we have quite different motives to patent or standardize. When looking at the barriers, however, actually it's very much related in both cases, in patenting or standardization. A barrier to patent or standardize is costs. Cost in application, cost in participating, cost in traveling, cost in a sense of time spending on going to standardization meetings, on filing an application. But in the end, costs is quite a relative thing, because you might think is something costly or not, always depends on my benefits. So the question is, why do the people don't see the benefits behind it? And that's where actually this session is maybe also about. How can we combine patenting and standardization? How do they interplay? Maybe in some fields they should interplay, maybe in others they shouldn't. And what we try to identify is how can we make the best of this cost-benefit analysis on patenting and standardization. So let's say you have a patent that is incorporated in a standard. This patent claims an invention that must be used by any company that complies with the standard. So we call it standard essential patent, meaning everyone using the standard is using the patented technology. And that has become a very lucrative market. I put up 3 examples here. First one is Fraunhofer and MP3. A very innovative technology coming from the research field, highly patented, introduced in standard setting, and then worldwide marketed. They had a royalty income of 2-digit million euros per year. I mean, now the patents are running out, but that was quite an income. Bigger companies like Qualcomm, who were among the ones that created UMTS and LTE, estimations say 3% of every sold smartphone goes back to royalties to Qualcomm. And Motorola, the same in the case for Wi-Fi. You can imagine how many devices now have Wi-Fi technology included, and they earn money from this, they get royalties back. So having a patent in the standard is a very lucrative, or can be very lucrative. However, these are good examples, or positive examples for the companies at least, but that's not always so easy, because you need to identify markets where patents and standards may work together in that field. You need to identify how your company can actually contribute to that standard setting. And in standard setting, of course, only solutions are accepted that are innovative enough, and you have a certain procedure where only the best solutions are in the end part of the standard. So that is a little bit what we do at IPlytics. We want to identify these markets. We want to identify markets for standard setting. We want to identify markets that may leverage your potential of a company in the sense of patenting. And we want the overlap of both. In which markets can you file patents and standardize at the same time? Either you file a patent and you introduce it into standard setting, or you might have a standardized solution and patent on applications that build on the standard. So what we do is we connect patent information, 80 million patents worldwide filed, to standard information to identify these different fields and different topics. We identify the overlap with standard essential patents. We identify which are actually standardization activities. Most companies don't even know what technologies are actually standardized and where and how can they participate, because there are currently standard setting initiatives coming up of new topics that might create a future standard that is very much relevant to your products, to future development of the technology. And we also look at licensing. How are these patents later on licensed? So we do that in a market analysis. Here I put up the example of smart home, for example, a future technology, or rather a future topic, not even a technology, that may come up, or that will come up in a sense of Internet of the Things, but that includes many technologies that have to communicate with each other, and that is done by standards mainly. So we identify these technologies, we identify the patents behind it, we identify the standards to then help a company to understand where to participate, how can I actually rank what is relevant for me as a company, how can I see that in a market perspective, where are my competitors, where are my cooperating companies, where do I have to investigate or invest in R&D, and where is everyone located, because standard setting, we all know that can be very international, but it can also be very local, as Laurent will tell us later on. That he started with a local standard setting project. So that is what we do in increasing transparency on identifying fields where you can standardize technologies or patent, or where it may overlap. And what we see right now, it more and more overlaps, actually. Thank you very much.
Well, Tim, thank you very much for this very interesting presentation. I was a bit, well, I wouldn't say really surprised, but I really found very interesting the fact that well, cost is a bit everywhere, so it's really about it everywhere. But also, I've seen that you mentioned time. Can you just maybe elaborate a bit more on this aspect? Because we've discussed about time this morning. So is it really linked to the time of development of a standard, or is it really the time that a company devotes to standardization activities?
I think in the questionnaire, there were two questions related to one and the other. One is, of course, cost, because you need someone to send there, and it takes time because you're developing a technology in many cases, and that, of course that employs a workforce. But the other thing is time, because usually when I have a problem, some companies fear that this problem can't be solved through standard setting because they feel it's bureaucratic, it's too slow. But I think that is something, again, has to do with image, especially lately. We look at LTE, a technology that was introduced more than 10 years from now into standard setting. We're using it today. So standard setting is much more right now in a future perspective. Now we have the cloud standardization projects, the smart home, smart grid standardization projects that will actually be technologies that we might use in 5 to 10 years from now. So I think that argument, it takes too long, my problem can't be solved in standard setting, might not be true anymore. Or we have to see standardization in a different perspective in that sense.
Yeah, indeed. Is there any question from the audience? Jackie, I pass the ball to you.
Anybody? Whoops. Turn the microphone the right way around, that always helps. Any questions at this point from anyone? Hang on, I see one just up here, and I'm going to leap up and get some exercise now. Where were you again, sir? Can you wave again? Ah, there you are. Thank you very much.
Thank you very much. My name is Friedrich Müller. You mentioned also the wording of essential patent. And in CENELEC there is an existing guide also to deal with the relation of IP and standards. What do you recommend if there's no consensus, if a patent is essential or not?
Thank you very much.
Yes, I mean, this is one of the complicated questions that we kind of expected. The problem of standard essential patents obviously is the licensing. So what is a fair price, what is a fair license, and also if it is actually essential. So in most disputes, this can only be decided by a court, or actually, in fact, it is always decided by a court decision if a patent really infringes and reads on a standard. So in some cases, we have patent pools where we have third parties that investigate if a patent really is essential, and then you have one single license. But usually, if a company doesn't believe the essentiality of a patent, this has to be decided in court. And this is, of course, a scenario that is not preferable, but I think is in some cases necessary to enforce a patent, which is something, or to maybe invalid a patent even.
Just on the speed issue for a minute, how quick is it to get a patent? Are the two processes very different in speed of processing, as it were?
I mean, you can get a provisional very quick, but you can also set a standard very quick, especially in the IT field. But the landscape is heterogeneous. You have de facto standards you can create within 1 week, but if you have a standard that is accredited by ISO or by a national standard body, it might take a bit longer. So, of course, maybe patenting can be quicker, but
not necessarily.
Not necessarily.
That's an interesting
Definitely.
point. Any others before we move on to get a little... Could you take that one right at the back, please? Thanks.
Yes, hello.
It's all right. You just talk. It will pick you up.
Okay.
Okay.
Matt Hackman, Maastricht University. Since you were talking about licensing terms, and you mentioned FRAND terms in your presentation, courts are struggling with the determination of FRAND terms all over the world. And some courts have said it could have been a task for standard-setting organizations to also discuss FRAND rates. What's the view of the standardizing world on this?
Well, most standard-setting organizations more feel like we're a platform for discussing FRAND, but we don't want to decide what FRAND is. And I believe that is a very good solution, because I don't think a organization should decide for a license that may have market implications that are very complex. In some cases, a small company licenses to a big one, an operator licenses to a producer. Having this in one contract, in one FRAND that exactly says what FRAND is, I believe is impossible and shouldn't be possible, because you have to change that in perspective.
Thank you. I suggest, Bardo, we bring in the next element, and then if there are any other questions, we can come back on that later on. But shall we add another ingredient now?
Yes. Thank you. Actually, very interesting question. To reply to this question, I think we could take all afternoon. But time is really an enemy as far as we are concerned. So let me introduce you, Laurent. He's going to give us a very good example of really interplay between the standards and patents. So Laurent, the floor is yours.
So the goal of that discussion is just to share with you something which is an experience. We are, as a small company, a unique kind of, as we join the AFNOR, the member of ISO in France. The very same time we've been dealing with lawyers on IP. That's part of a way to have something in mind on a long-term vision. Here, that's the most important thing to have in mind is that whatever your innovation is, you are in an ecosystem. What we do is to link things between what is printed using either QR code or NFC, using a link through a URL, and going using a mobile device. So we do not reinvent the wheel. There is things that exist in the printing industry, there are things that exist how to define a link. Those objects are already known, already defined, the same in the mobile world. So we have to act in that ecosystem. So prior to do anything, we had to understand what AFNOR was bringing as a standard, ISO. On the other hand, the usage, because some group of people, GS1, are working not on technical point of view, but on the usage, the commerce. How could you leverage something in the commerce world? In the internet world, the W3C have some specification you may follow in order to create those links in a smart way. So we made the choice to join, next slide, the ISO through AFNOR, to join GS1 and to be a member of W3C. But the goal is just not to have that little logo on our documentation. That's not the goal. The goal is to ensure quality of what we do produce. You can claim you are reliable, but the only real thing is to test and to check that it is. The compliance to a norm, you cannot say, I'm compliant. You have to go through the test process to have that certification. And interoperable. If somebody wants to use what we do to read those things, that's the only way to go. So the norm defined, here, that's an example, what is a QR code? It's not that readable. Then, through your knowledge, you might say one is compliant and another is not compliant. So instead of claiming that we are compliant, we went through the process following other standard that defines how to test something to get a result. And that's a machine. It's an automated machine that gives a result. The goal was not to do something nice, but to be able to sign with major companies. Companies such as L'Oréal. They wanted something lovely, but that always works, whatever the device was used to scan those codes. As soon as you deal with the industry, with packaging, they have specific rules for you to follow. So you have to stick to those rules. The goal, when you produce 6.3 million products, you don't want to jeopardize that link, and you want that to work. On one brand or another brand, 7.3 million products, there is a link on each pack. You want that link to be reliable. Here, that's another example using the technology. The thing is, it's a switch, a light switch that you have in France at SFR headquarters. With Schneider Electric, instead of having some physical switch, that's a digital one. You may tap using NFC or scan to turn the light on and off, to remotely control the AC, even everything which is in a room. So you have 25,000 switches all over the place, and you want them to be reliable and them to work. When you want such that bank Natixis to create links between each and every shop, it's 225,000 places. You want that link to be reliable. And that's a request that comes from the industry. You have to own your IP. That's one thing on how to create things, but you have to be compliant to the norm and prove that you are. Enhanced visibility. That's true that as a small company, if you have IP, that's one thing. If you are able to prove that you take part, an active part in norm, then companies such as Forrester, analysts, you can be seen from those people. Or Axicon, a specialist in test, that claim that what you have has value. And it's related to the fact that what we do produce is compliant to the norm. What we have, in fact, in mind is always two things. On the right side, the fact that we are part of member of AFNOR, and AFNOR is member of ISO. So we do share things with those groups. But on the other hand, we have a portfolio, one on computer graphic, another one on Internet of Things, performance. So we will not reinvent the wheel on IoT, just to create value on top of something that already exists. For you to understand where we are, you do not manage millions of requests to a server the way you do when each object is unique. So imagine on the back you have a code, anybody could access to that code, but it's always the same request that goes on the server. So you may manage millions. But as soon as you go into the IoT field in which each object is unique, each object has a unique link to talk to a server, you have to manage with billions of unique objects. And that's really tough. That's where we are. So being part of those groups, of course, that's time-consuming. We have to bring the expertise we have to the group, and different group, W3C, ISO, or GS1. We gain knowledge because we know something, but not everything. So talking to the other person in the network helps us to increase our knowledge. Then, and later on, we can influence the norm, giving some input to the norm and sharing. Part of it might be used as an IP, but another part might be given to the group. The best thing is for a small company to have a vision of what's happening 5 years from now, 10 years from now. And that's the long-term vision we gain from those groups, from the norm. But we have something might be unique. A partner called France Brevet. And the way it works, they did an audit on the IP we had. They asked if we were involved in norm to be helped not only to have a licensing approach, that might happen, but also to share to the group. And the reason for that is whatever your technology is, it has to fit the ecosystem. If you are willing to give, either using friend or royalty-free approach, part of your IP, you may help your IP to be stronger and to develop things on top of something that will be shared by billions of people. That's the approach. But the thing, in order to do that, we had a partner able to invest in that approach, because usually investors are not willing to invest money in your company if you want to give things for free. Some others are able to understand that it's only giving part of it just to have a better knowledge, a better influence in the market. And not the end, but one step in the evolution we had is having been able to manage both IP and norm was extremely helpful for a modest company to gain the Red Herring 100 company. So Red Herring is known to help companies raising money, being focused on IP only. Be sure that having some company involved in norm for them is also key. And that's a change. Thank you.
Thank you very much. Thank you very much for your very interesting presentations. I would like Julie to make just a few comments. First, the first thing is that it seems to me that to participate in standardization activities is very, very important, even for a small active company. You don't need to be a multinational to see the interest in standardization, which is a very important key message that I think we need really to spread out. Then I can also see that before somebody from the audience asked a question on essential patterns, but here really we have two kinds of patterns that interlace with standards. So from one side we have essential patterns, and from another side we have non-essential patterns, but still that can be used as a tool to implement the standards. So, and I think this relation is very important also to keep in mind. So it is not necessary to have a pattern in a standards, but but also patterns outside the standards can be used in order to implement that standards. So do you have any comments on that relations?
It comes back to the question you had on even for a small company, that's a choice or which strategy to follow. If you believe in something that might be great, but with no market at all, and you're not strong enough to be a standard de facto, if that might be useful to others, then your strategy is to share. Because if you have that component shared by others, you may create value on top of it. So that it's hard to describe, because it's the policy, the strategy you select is based on what the market offers. Usually, and it was seen several times, the IP was too expensive to manage, too expensive to defend sometimes. So company made the choice to give it for free, but just it's on failure. We are not there. The goal is just to have a clear view on what already exists, not to reinvent the wheel, to benefit from what already exists, to listen to specific requirements of missing part on what already exists, and might be to share it in different way. But the thing, I'm really convinced that it's better to have a modest piece of a big cake than the whole cake on yourself. I mean, it's really true. It's really true. And what you saw with MP3, that's more than true. That's more than true. It exists.
Okay, well, thank you very much. Maybe Jackie, maybe we will like to ask some questions.
Any questions to Laurent about this very practical example of the combination of the two? Does anybody have a question? And do remember as well, if you have a thought bubble. Do you see one?
Yep.
Where? Yes, right in the corner there. Hang on a minute. And if I can remind you, if anybody's too shy to put their hand up but wants to raise an issue, I can collect these as I am moving around. So, please, sir. Thank you.
Marek Ribo, DIT Ireland. I have a question about sharing creativity. We know that IP and patents are in only one way. What about Creative Commons license, and how Creative Commons can influence standards?
Thank you. Laurent?
Creative Commons, I saw that, but I'm not that, let's say, used to. But you're right, there is many methods to share things. There's many methods. The only thing you have to have in mind is if you have IP which is in the process, you should not disclose things. I'm really in favor of sharing things, but on purpose. And sometimes it happens just, it might be an error. But to do that on purpose, that's great. And there is, you're right, many methods to do so. Sharing is also a way to protect yourself. Because if you are convinced that your technology is great, if you don't want to, if you don't have the money for it, to fill a patent and push it, giving it for free to everybody, that's also a method for other people not to feel it. But it has to be made on purpose. It's part of your strategy. Just to give things if you want to.
Thank you very much. Any other questions specifically for Laurent before we get the third element of the equation into the picture? Just one quick one, if I might, Laurent. We're talking as well about not only about how people can benefit from all of this, but how the system can be made easier for more companies to get involved. Do you have any suggestions? Did you come up against particular barriers in combining the two things? Is there any idea you would have, suggestion you would have for improving the process in future? Is it the speed or?
Might be speed, yes. Because you said things about rhythm. The first patent we filed in 2011 was, let's say, valid in France 3 years after. That's a long period of time. Then comes the, during that period of time, you have the PCT phase, then the local deployment. So what we had in mind, let's say in 2010, is not deployed yet everywhere. And then comes the second patent, which is an investment for the coming 5 years. So it's a long period of time for what is called a startup. So we are probably slow to start, but with many things in mind. And the same with comparing the IP process with the normalization process. They are close. I mean, even if you have something you want to share, prior to that to be written in paper, validated by different countries, part of the process takes a long period of time. What I'm just saying is, if you have in mind that this is going to be shared, you can, even if it's not written in stone yet, you may start working on that. Just not to be surprised as soon as a patent is out, just not to be surprised as soon as a norm standard is published, that everything you developed is obsolete. So for a small company, it's extremely important to see prior to others. And talking about time, that's a different kind of investment. You may pay for studies, and I have nothing against studies when they are really well done, but it might cost a lot. Taking some time to develop your network on IP and norm at the very same time, improve your knowledge, and that has the benefit is incredible.
Thank you.
I'm telling that.
Which goes back to that integrated approach we were talking about, Bardo. Bardo, just to mention one thought bubble. Considering that EU harmonised standards, although not compulsory, assume a quasi-law-abiding power due to the presumption of conformity, shouldn't they be made available free and not be subject to copyright? Brackets, it says here, with the compensation being paid by EU bodies. A thought for later on, but should we move on and get the third element of the picture now?
Yeah, maybe, well, before, because of course this is not about patent, it's about copyright. But I will be happy to reply to this question later on. I would like maybe to give you the floor, Jed. So to drive us through, let's say, the tips and challenges that you may face when filing a patent, and also the relation between patents and standards, of course, from a perspective of European Patent Office. The floor is yours.
Thank you very much, Bardo. I'm not going to go into great detail about the tips and the tricks because it's a complex area, but I'll share a few thoughts with you. Just one to start off with. We've talked so far about the speed of the patent process. The patent process is something that you can accelerate if you want to. You have the ability at the European Patent Office to request accelerated search and examination at any time, free of charge. So you can make the process faster if you want to. What tends to happen is people like the fact that the process takes a long time. They push the costs out, and they also keep their competitors wondering whether they will get a patent or they won't get a patent. So it's not necessarily the fault of the Patent Office that things take a long time, and it's something worth considering that you can accelerate the process free of charge if you want to. Okay. My name's Jed Owens. I'm the coordinator for public policy issues in the European Patent Office, and patents and standards is one of those areas that I deal with. I've lost the cover sheet off the presentation, but what the cover sheet says is that the European Patent Office, its mission is to promote innovation, competitiveness, and growth in Europe. And if you think about those words, innovation, competitiveness, and growth within Europe, those are things that the standardization system is also trying to achieve. So I think that's the first thing to note. The patent system and the standardization systems are both innovation support systems on a national and a European and an international level, and that they're basically trying to do the same thing. So therefore, it does make sense that the two work in unison. That's the slide that I couldn't find earlier. What I'd like to emphasize first of all is the potential benefits of patents and standards. We all have these days smartphones, and altogether there are 7,000 million registrations for mobile phones in the world today. It's approximately one for every single person on the planet today. And that is a successful industry. You might argue that there are problems between Samsung and Apple and other companies, and that there is litigation and that there are arguments. But when you consider the billions of euros that are involved in this market and in this technology, then you have to accept that there is, under normal circumstances, a certain amount of strife and battles and market share battles, etc., that are going to go on in an industry like that. So really what I want to say is patents and standards can work, and here is the #1 example of how well they can work. The reason is, in particular, is that all of us today, we want faster networks, we want lovely touch screens, we want all the beautiful graphics that come with this, we want the apps, we want the applications, we want the maps, Google Maps, etc. And all of that comes through interoperability between all of the components here. So that the mobile phones are a combination of all of the new technology that we all want and the interoperability. So what you've basically got is you have patents in here in very large numbers, which are the results of millions of euros of research and development money poured in by companies. Those companies will only do that if they get a reward on their investment. And that's what the patent does. It gives a temporary exclusive right to the people that invested and developed this technology. At the same time, they need the interoperability, and the interoperability comes through standards. So both patents and standards are innovation support. And if you can make the two work together, then you have a potential, not everybody, but you have a potential to be as successful as the mobile phone industry, potentially. The forerunner of the interaction that we have between the patents and the standards is in fact at ETSI. ETSI is the European Telecommunications Organization that helped develop 3GPP and other compatible technologies. If you look on the database of standard essential patents at ETSI, you'll see that it's over 10,000 patent families. It's well over 100,000 patents, because each patent family is often a set of patents in different countries. And therefore you see the extent of the interactions there between patents and standards. So that's the success story. There are some key rules that you must comply with when you start to work with patents and standards. And does anybody know what the #1 rule is? It applies to patents and standards, it applies to scientific research, it applies to anything else. It's basically, you must apply for the patent before you tell everybody else about it. Because if you tell everybody else about it, it's no longer new, and then you can't have a patent for it. And the same applies at the standardization procedure. You must apply for the patent before you come and discuss this technology at the standardization procedure, because otherwise it will no longer be new. The rules are very clear, and you must abide by those rules. Why are we so strict on that? Because we want to grant patents to the genuine inventors and the genuine developers. And they know when they have patented technology, patentable technology, and therefore they should apply for the patent first. What we do with this procedure is we avoid people sitting at a standardization table, hearing of the different technical solutions from different people, and going away and patenting them afterwards. What we do at the European Patent Office is we collate all of the documentation from key standardization organizations, in particular from ETSI, from IEEE, from ITU, and the people in the telecommunications area. We have over 1 million standards-related documents in our databases, and we use those to examine whether something is new or not. So that is the second thing. First rule is patent before you standardize. Second rule is we will gather the information and make sure that patents are only granted for things that are new and inventive, and hopefully to the genuine inventors. And the third rule, basically, is what is written into the IPR policy of the standards development organizations. And that is, if you want your patented technology in a standard, you must agree to license it to anybody who wants to use it, either royalty-free or on FRAND terms, fair, reasonable, and non-discriminatory. And with that, you should be able to make patents and standards work. I was talking about us using standardization documentation to make sure that the patent applications or the patents that are granted are only new and inventive. This is a graph of the citations of standard documents that we use to prove that things are not new and not inventive. We've accumulated more and more documentation as we've gone on, but you see there the rising curve. We've used over 14,000 documents last year to prove that particular patent applications were not new and not inventive, because somebody had already discussed it around a standardization table before. And we will continue to follow this process, and we can believe that it will become more and more important. We have a number of agreements with standardization organizations, and there's two key things that we try and achieve through those. Firstly, it allows us to gather all of their documentation and use it in the patent process. And secondly, it assures us and everybody else that the documentation that we get can be used to prove that things are not new and inventive. And with that collaboration with the standards documents, we minimize the exclusive rights in standards to what it should be, and avoid people getting patents in standards when they're not eligible. What we see then is we've worked a long time with ETSI, with ITU, to maintain a high quality of patents in these areas and make sure that patents and standards work together. What we're now seeing is that the number of standardization areas that have patents in them is growing all the time. So we talk much more now about smart grids, smart transport, smart buildings, even smart cities. And that is the incorporation of computing technology into traditional industries like the electricity industry, like building, manufacturers, and so on. And there we see that making patents and standards work is more and more important across a much wider range of industries. So we're working more now with IEC, with ISO, with CEN-CENELEC to try and pave the way to make sure that patents and standards will also work in these other technical areas. And I think that's really what we're trying to do here today as well, is educate people that patents and standards can work and that there are big advantages in trying to get a synergy out of those two systems. So, just one more graph. This is the relative increase in patenting over this period of time. You can see that patenting across all technologies is increasing slowly all the time. But if I look at something like smart grids, it's going up very, very fast indeed, at a much, much higher rate. That's just an indication of one of the things I was saying about how patents and standards are starting to be necessary across a much wider range of industries. So, thank you very much.
Thank you very much for this very, very interesting presentation. I have just a couple of comments. The first one is that, you know, collaboration, and we have really a pretty sophisticated system here, definitely. I mean, and a very good system of standardization in Europe. And the cooperation that European Patent Office has with ETSI, but also with us, and we have actually, we are engaging in lots of discussion with the European Patent Office, demonstrate that synergy works also, let's say, a more organizational, institutional level. But also, I think that is very important to keep in mind, not only to have a strategic view on how to let's say, to combine patents and standardization, but also to have very practical approach and timely approach. Because otherwise, if you miss the train, then you have a problem here. And so thank you very much also for clarifying really these aspects on timing or timely, let's say, communication of novelty of patents also in the standardization field. So do we have any questions?
Let's have a look.
Yeah.
Anybody have a... Yes, please. Hang on a second, sir.
Thank you. My name is Kirit Lathia. I represent Global ICT Standards for India, GIFSI. And what I wanted to ask all of you is something which has already happened, and therefore, what do you see it? And that is, I think all of you are aware that ETSI was taken to court in the United States by True Position on the basis that its patents, essential patents, were not included in standards with the processes which were set out by the SDO. Finally, the case has been resolved. It has been resolved out of court. It has been, but it was a very, very expensive case where a standard body was taken to court. What sort of opinion do you have? What can happen in this environment of using standards, patents, and as you said, patents do generate revenue. So the question was, my revenue stream has been blocked, and it is the fault of the standard body who is providing the platform.
Thank you very much. Can anyone help us with that one?
It was a very complicated case, and actually, as you...
They're all looking at each other. Tim,
Yeah.
are you going to jump in?
Yeah, just maybe in parts. Not, I mean, I don't have a solution directly, but that comes a little bit to the point we had earlier on that standard setting body should state FRAN terms, and that's exactly a reason why I believe they should be not involved in these kind of things. They should only maybe organize the declaration of standard essential patents without saying these are really standard essential, because this is, as I said, a court has to decide in the end if it is. So they should only be a platform for discussion, but not getting involved in really deciding these. So that, yes, but no, but ETSI is, they always claim everything that is declared can or cannot be essential. That's a company that does it.
Okay. Fairly complicated issue, maybe a little bit of a bilateral over coffee. Can I ask you, yes, sorry, you wanted to come in again. Yes.
I don't want to stop any further discussions. A number of comments. I'm not saying that patents and standards is perfect. I don't wish to say that. I wish to say it's been hugely successful, and it could, the telecommunications industry and smartphones, etc., could only have worked if the people playing in those areas had managed somehow to work with each other. There has been a lot of litigation, and there are still many problems. There are people that use the standard technology and don't pay the license fees and delay negotiations. I mean, I've heard all sorts of stories from all ends. I've heard stories that people declare far too many standard essential patents, and there's no penalty for declaring more. We've heard people demanding injunctions, which is effectively a gun to the head to demand more rights from people. I'm sure that somewhere there are, all of those stories have been true, just like somebody at some point has been pickpocketed on a Brussels street, but Brussels is generally a good place to live. And
so as you said, it is not surprising in this area that there will be some tough times and difficult litigation, but that doesn't mitigate. I'm going to go, if there's any more thought bubbles or anything, but you said, Bardo, you promised you might pick up on the copyright issue.
Yes, on the copyright. There's a
and then I want to ask you all a final question, if I might.
Completely different environment. Well, first of all, let me just clarify that standards are voluntary, so they are not compulsory. And even when we talk about presumption of conformity given by standards to the law or to the European regulations, for instance, is one of the tools that you can use to make sure that your product is conform to the legislation, but it's not the only one. So that just to clarify that we are not talking about administrative acts or laws, but standards remains a document, a tool that is used on a voluntary basis. With that in mind, standards are also an investment. Investment for all those who spend time, for all those who have to organize a very complex and sophisticated systems to make sure that everybody can have a say. And that has a cost. And somehow we need to recover this cost. And that's the reason why, although we tried and we have, let's say, a dialogue also with the European institution on a, I would say, on a very regular basis about how to promote standardization also in terms of reducing costs and making standards, say, affordable, for especially for small and medium companies. So there is a cost, somebody has to bear the cost, and we try to, I mean, our members, they try to make it as much affordable as possible, but still...
Okay, we're almost out of time, and in my role as provocateur in these sessions, I want to ask you all, including, if I might, you, Bardo. It really goes back to a question I asked at the end of the plenary this morning. If you had to give people one piece of advice, somebody in this room who didn't put their hands up twice, they're involved in standards or they're involved in patents, but they're not involved in the two, and they are thinking, they're listening to this and seeing the opportunity, seeing the advantages. One piece of advice, and it's sort of half a minute each if you would, for how they should go about it. What do they need to do? What would it be? And I'll do it in the reverse order to how you spoke. So, Ged, you told us the rules, file for your patent before you go down the standardization road, you explain. But in terms of advice as opposed to absolute rules, is there anything you would say? Can you grab a mic?
Can I delay and pass on? Because
Sure.
I'm going to think about it. Because my number one rule was
Yep.
the one that you just stated.
Yep.
It's the fact that you patent before.
Yes.
So now
Yeah.
I get another chance. I'm going to pass the microphone
I'm going to ask
on.
Laurent, because he has very practical experience of this. Based on your experience, what would you advise them?
On the piece of advice?
Yeah.
Don't be shy. No, don't be shy to share some knowledge, because even as a small company, you might be seen as an expert. You know few things, but you know it well.
Yeah.
So you have something to share with others, and you're welcome.
Thank you.
And I guess that's not only the case with AFNOR, but other organizations. You are welcome. And on the IP side, again, don't be shy, because your idea might be a good one or not. So you have to face some
need to
expert
find out.
that
Yeah.
will challenge you to say if your idea has no value at
Super.
all, or if it's key to some business.
Okay.
So don't be shy.
Okay, you don't have to give advice. Tim, do you have any advice?
Yeah, my advice would be try to identify and see the opportunities, because most of the companies, they shy away from standard setting or patenting because they don't see the direct benefit. But if they would look more carefully, what topics are standardized actually, what very current topics that will have a good influence in the future, they should identify these for their company needs or company segments, get involved, have an integrated approach of patenting and standardization at the same time, and commercialize it.
Okay. Anything else to add, Gerd or Bardo? Gerd, and then Bardo has the last word.
Okay. Building basically on both comments. Firstly, if you think you have patentable technology, then try and patent it. You have to do that first anyway. And you can work carefully to delay some of the costs if necessary. So patent it first. If you need to delay some of the costs or whatever, but if you've patented it first, then both routes are still open to you. Don't be shy then. Go into the standardization process, and also don't be worried in advance about the stories about FRAND and so on. FRAND has simply got to be negotiated. And FRAND, what is a fair and reasonable return? It's simply a concept. And people try and give you guidelines, like work on the smallest possible component, work on your contribution to that technology, etc., compared with other people's contributions to the technology. So there are some guidelines on helping to define FRAND.
Thank you very much.
But go into it.
Don't be frightened, don't be shy. Bardo, a very brief last word from you as the session moderator.
Yeah, just do it, as it was said this morning.
We go back to just do it.
We are there, and now I speak as a CEN-CENELEC director, legal affairs. We are there to help. So, and one of our role is really, to make sure that the rules are applied and to clarify them as much as we can. for all stakeholders. So don't hesitate
Okay.
you know, to come to us.
Okay, we are out of time and we have to be very strict because another session is about to begin in this room. So, ladies and gentlemen, will you join me in thanking Bardo and all our speakers
thank
very
you.
much indeed. Thank you so much.
Thank you very much.
This room will now become Horizon 2020, so if you want to stay for that, stay here. If you want to go to one of the other breakouts, can you make your way there as quickly as you can? There is no interval between the two breakouts. So if you could go straight to the other one if you're leaving, or
Thank you, Jim.
we'll let in the people who are coming
Sorry?
to Horizon 2020
Yeah,
now in
well,
here.
the
Thanks
text
very
will-
much.